Good evening to you all. Bonsoir. My name is Christophe Paulussen, and I would like to welcome you to the Astor Institute and again to a new Supranational Criminal Law lecture. And like the previous two lectures, I would like to extend a special word of welcome to the participants of the summer law program on international criminal law and international legal and comparative approaches to counterterrorism that the Astor Institute is currently organizing for the 11th time in cooperation with the Washington College of Law. Now, for those of you who are not familiar with the Supranational Criminal Law lecture series, this is a lecture series on international criminal law and has been organized since 2003 by the Astor Institute in cooperation with the Coalition for the ICC and the Grotius Center for International Legal Studies of Leiden University. Now, tonight's lecture is special in that it's organized in cooperation with another partner, namely Open Society Foundations. And at this point I would like to thank OSF and Mariana Peña in making this lecture possible. Could show where she's... there you are, hiding. So tonight's lecture is entitled Can Africa Prosecute International Crimes? The DRC example. And we have a very interesting panel for you consisting of 4 speakers. The first speaker is Nick Elebe Ma-Elebe, and he's a lawyer and human rights defender from the DRC, where he has directed the local office of the Open Society Initiative for Southern Africa, or OSISA, since 2012. And he was previously the program officer for rule of law and governance at the OSISA. And before joining the organization, Nick Elebe headed a project on the fight against sexual violence in the Great Lakes region at the Agency for Cooperation and Research and Development, or ACCORD. He also contributed as civil society expert to the bill on the specialized mixed chambers in the DRC, and Nick Elebe was also an intern at the ICC Registry's Victims' Participation and Reparations section in The Hague back in 2007. And he will give a brief introduction of some 3 minutes. Now, the second speaker is Jacques M. Bocani. He holds a Master in Human Rights and a PhD in International Criminal Law from the Université Catholique de Louvain in Belgium. He's a professor at the Goma University and a consultant for OSISA in Kinshasa in the DRC. He recently authored an OSISA study on Congolese military tribunals jurisprudence on the application of the Rome Statute, and this was published in 2016. And Dr. Mbakani was an intern at the prosecution division of the ICC Office of the Prosecutor some time ago. And he will provide the main conclusions of the OSISA study for some 7 to 8 minutes. Now, the third speaker is Emmanuel Kabengele Kalonji, and he holds a bachelor's degree in law and has more than 16 years of experience with the civil society movement in Congo, specifically in the human rights sector, the security sector reform, transitional justice and local governance. He's an attorney, a human rights defender, and a national coordinator of the Network on Security and Justice Reform. Now, he's written analysis on national and international public policies, on stabilization and security reform, and the most recent of which is entitled Electoral Risks in Central Africa, the Case of the Democratic Republic of Congo. And in some 5 minutes, he will present the lessons learned from the study for the reform of the justice and security sector. And the fourth and final speaker is Frank Kamunga Sibangu. He is a human rights lawyer. He's a Stanford University Fellow on Democracy Development and Rule of Law, an Oxford University Fellow on International Humanitarian Law. And Frank Kamunga is the team leader for Rule of Law, Access to Justice and Human Rights at OSISA. He has over 15 years of experience in human rights and rule of law, governance, gender equality at global and continental levels. Frank Kamunga previously held several key positions, including coordinator of the African Democracy Forum in Nairobi, legal advisor to the Electoral Commission in Kinshasa, communication and fundraising specialist at the UN Women Country Office in the DRC, Executive Director at Droits Humains Sans Frontières, and Senior Legal Advisor in the Office of the Representative of the President of the DRC on the fight against sexual violence and child recruitment in the armed groups and forces. And in some 5 minutes he will speak on the lessons learned from the study for OSISA. Gentlemen, thank you very much for coming. We're very honored to have you with us here tonight. Now tonight is special for another reason, in that the presentation will be provided in French. Luckily we also have Jonathan there in the middle with us tonight, who, as you can see, is now already taking care of the consecutive translation. So Jonathan, thank you so much already in advance for your assistance tonight. And again, many thanks to OSF for making this possible. Now, as we have quite a full panel plus consecutive translation, I will have to be a bit strict when it comes to the timekeeping. And that's also why I mentioned the time allocated to each speaker. So apologies in advance if I have to ask you to conclude. And after the presentations, there's of course some time for Q&A. Now, with every word that I say, we lose minutes, so let's quickly turn the floor over to our speakers. Thanks again, and Nick, you have the floor, and you can stay here or you can sit down as you prefer.
Yeah. Thank you so much, Christopher, and thank you also to Asser Institute for having us. Normally in this moment of the journey, my English gets sick, but for the purpose of the time limitation, I will go directly in English, just to give you an overview introduction on the work that Open Society Initiative for Southern Africa is doing and what led us to develop that study. We are working in Democratic Republic of Congo back to 2007 actually, and one of the things that we are working on is also to try to build knowledge, to product knowledge, because we are in a situation where we want our programming to be based on the research. We want also partner we are working with to build their advocacy, their activity also on some key knowledge, so that they are able, when they are interacting with the state authorities, when they are interacting with people on the field, to base every activity that they are doing on knowledge that are coming from deep analysis. That's the reason why this kind of study are particularly important. And in Democratic Republic of Congo, we have worked in several studies actually on justice and rule of law, on media, on political participation, on delivery of social service such as education. And on justice and rule of law, this is like the third study that we are publishing. The first one was about the military justice system. The second was about justice and rule of law in DRC. And now we have that first study on Congolese jurisprudence on international crime. This study is particularly important because there is actually decision coming from Congolese justice system. There is actually plenty of them, but for the majority of us, that production is not well known. It's also particularly important to discover also through the different decisions provided by the Congolese justice system what have been the challenges, what have been difficulties, what have been the learning coming from the Congolese justice system on implementation of the Rome Statute. What have been the idea that Congolese judge was able to develop in terms of trying to face the issue of impunity for international crime. So that study is providing some key idea about that reality. It's providing also idea on the existing gap, so that everybody who is trying to build, programming and engagement on fighting against impunity in Democratic Republic of Congo is aware about these challenges and also take it into account. So that study is particularly important for us for that purpose, and it's involving the analysis of about 30 judicial decision coming from Congolese court, and we are very pleased to be here with you and to be able to share also the experience and knowledge coming from that study. I think I have 3 minutes, and I think that I'll say some word of introduction. Thank you so much.
Thank you, Nick. You even have 1 minute left. That's unbelievable. Let's go to the second speaker. If you want to stand? Yeah, sure.
Bonsoir. Je vais vous présenter assez rapidement les grandes lignes de cette étude. Je commencerai par une problématique générale. Je vais poursuivre avec un aperçu global de la jurisprudence ainsi que la structure de l'étude. Et ensuite, le quatrième point, ce sera les principaux constats et recommandations. Et je terminerai par les conclusions.
Well, good evening to all. I'm going to present you my study, and I will start with the problem analysis. So the problem I decided to analyze, the context as well, so the background of these problems. I will then give you an overview of the jurisprudence, the case law in Congo, and I will talk a bit about the structure of the study. And then I will try to elaborate on the findings of the study before moving on to the conclusion.
Oui. La jurisprudence congolaise issue de l'application directe du statut de Rome est-elle conforme aux standards internationaux en matière de justice pénale? Telle est la principale question au centre de cette étude.
So the key question in this study is whether Congolese jurisprudence related to the direct application of the Rome Statute is in compliance with international standards when it comes to criminal justice. So that's the key question I've studied.
Les affaires à l'origine de cette jurisprudence portent sur des incidents survenus dans le contexte d'une instabilité politique qui peut remonter depuis les années 1990.
So now about the background of these legal decisions. Well, you have to know that they were handed down in the context of a political instability that dates back to the regime of Mr. Mobutu in the 1990s.
Et cette instabilité est caractérisée par des conflits armés répétés qui persistent encore à ce jour, et notamment à Beni et au Kasaï.
So this instability is characterized by a series of armed conflicts that are still ongoing today, and in particular in the Beni and South Kasai areas.
Et ces conflits armés sont accompagnés de violations graves du droit international humanitaire et des droits de l'homme imputables aux forces armées gouvernementales ainsi qu'aux groupes armés.
And so these grave violations of international humanitarian law and international human rights have allegedly been committed by the government forces and by the rebel movements.
Et bien que la plupart d'entre elles aient été largement documentées par les ONG et les Nations Unies et qu'elles soient constitutives de crimes au regard du statut de Rome, il s'avère que la réponse judiciaire jusqu'ici réservée est limitée aux crimes commis après 2002.
So despite the fact that these violations have been widely documented both by NGOs and the United Nations, and that they constitute crimes under the Rome Statute, so far the prosecutions have been limited to crimes committed after July 2002.
Alors, le deuxième point, aperçu global de la jurisprudence et structure de l'étude.
So now I'm going to address the overview of case law and the structure of my study.
L'étude couvre une trentaine d'affaires pour des décisions qui s'étalent de 2004 à 2015, soit 10 ans.
So the study encompasses more or less 30 cases in the period going from 2004 to 2015.
Le nombre d'accusés accusés dans ces 30 affaires varient entre 70 à 80 individus, comprenant les militaires, les policiers, les membres des groupes armés, les Maï, FDLR, etc.
So in these 30 cases, there are between 70 and 80 defendants accused, among which soldiers, members of the national police, members of armed groups like the Mai and the FDLR.
On y trouve aussi des femmes.
And among them are also women.
L'étude est articulée sur 6 points ou chapitres.
So there are basically 6 chapters in this study.
Le premier traite du cadre juridique.
The first one is about the legal framework.
Le deuxième, la place des exigences contextuelles dans la définition des crimes de droit international.
So the second chapter is the role of contextual requirements in defining crimes under international law.
Le troisième, c'est à propos des formes de responsabilité pénale individuelle.
The third one is about individual criminal responsibility.
Le quatrième point porte sur la fixation des peines.
The fourth chapter is about sentencing.
Le cinquième point traite la question des droits de la défense.
Chapter 5 is about the rights of the defense.
Et le dernier chapitre traite de la place des victimes et principalement les questions de droit de participation ainsi que le problème de l'indemnisation.
And last but not least, the last chapter is about the role of the victims and the way they can participate in the proceedings and the reparation issue.
J'entre dans le troisième point qui touche sur les principaux constats et recommandations.
So now I'm going to move directly to point 3, which is about the main findings and recommendations in this study.
Alors pour gagner du temps, je vais me limiter à 3 principaux constats et recommandations.
So in order not to lose time, I'm going to stick to 3 findings and recommendations, key findings.
Premièrement, le cadre juridique de la répression des crimes en RDC est essentiellement marqué par une volonté de juridiction de recourir au statut de Rome pour combler les lacunes de la législation nationale.
So when it comes to the legal framework, there is a willingness in Congo to use the Rome Statute in order to fill the gaps of national domestic legislation.
Et tel est le principal point fort de ces jurisprudences.
And that's the main advantage, the strongest point of these decisions.
Toutefois, l'un des enjeux de l'application du statut de Rome en RDC réside dans sa rétroactivité ou non.
So one of the key challenges in DRC is to figure out whether the Rome Statute can be applied retroactively or not.
Et la question est celle-ci. Le statut de Rome est-il applicable aux actes commis avant 2002?
And we need to ask ourselves whether the Rome statute is applicable to crimes committed prior to 2002.
Les tribunaux congolais y ont implicitement répondu par la négative, raison pour laquelle ils n'ont poursuivi que des faits commis après 2002.
So Congolese courts have answered this question saying that it wasn't the case, and that's why they have prosecuted and adjudicated cases that took place after 2002 only.
La question de la non-rétroactivité se pose également dans les 3 lois de mise en œuvre du statut de Rome promulguées en 2015.
So this question of non-retroactivity is also key to this in the 3 implementing legislations that were promulgated in 2015 in Congo.
On constate en effet que ces trois lois sont silencieuses sur la question de savoir si elles sont rétroactives ou non.
So there is nothing in these laws about the questions of retroactivity.
Cependant, l'arrêt de la Cour d'appel de Lubumbashi dans l'affaire dite du génocide des Pygmées, que je ne traite pas dans cette étude parce qu'elle est intervenue après.
So there was a decision by the appeal court of Lubumbashi in the Pygmy genocide case, which I didn't address in my study because it occurred after it was written,
qui semble y avoir répondu également par la négative.
and in this decision the appeal court seems to give a negative answer as well to the same question.
En effet, bien qu'ayant été rendu en 2016, donc après les lois de mise en œuvre du statut de Rome sur des faits de 2014, l'arrêt a préféré appliquer le statut de Rome et non les lois de mise en œuvre de 2015.
So despite the fact that the decision was handed down in 2016 about facts or crimes committed in 2014, the court chose to apply the Rome Statute and not the implementing legislation that was adopted in 2015.
Et la Cour n'explique pas ce choix.
And the court did not give any justification to this choice.
Il me semble que la réponse gît dans le fait que la Cour a considéré que les lois de 2015 n'étaient pas applicables à des faits commis en 2014, donc que ces lois n'étaient pas rétroactives.
So the answer to this question lies in the fact that the court thought that the 2015 legislation was not applicable to crimes committed in 2014.
Il est pourtant important de rappeler que les crimes prévus dans le statut de Rome et même dans la loi de mise en œuvre du statut de Rome étaient prévus dans les textes juridiques internationaux ratifiés par la RDC avant le statut de Rome, et que dans tous les cas, ces crimes font partie du droit international coutumier.
So it's important to mention here that the crimes included in the Rome Statute and in the Congolese legislation were also in legal texts that had been ratified by the DRC long before the entry into force of the Rome Statute, and that they were part of customary international law.
Il est donc important que les tribunaux affirment le caractère rétroactif aussi bien du statut de Rome que des lois de mise en œuvre afin de permettre la répression des crimes commis avant 2002.
So it's important that the courts and tribunals assert or confirm the retroactive character of the Rome Statute and of the implementing legislations in order to fight against crimes committed before 2002.
Je passe au deuxième constat, et donc je saute pratiquement ce que j'avais prévu. Je vais traiter la question de la fixation des peines.
So I'm now going to skip a few chapters and move on directly to sentences.
Oui. Sur la question de la fixation de peine, l'on peut saluer cette tendance des juridictions congolaises au rejet de la peine de mort, et même si elle a été confirmée par les 3 lois de mise en œuvre de 2015.
So I'd like to praise the Congolese jurisdictions for not applying the death penalty in all these cases, even if the death penalty has been confirmed and upheld by the 3 implementing legislations of 2015.
Toutefois, le rejet de la peine de mort est accompagné par une application trop sévère de l'article 77 du statut de Rome, puisque les juges congolais prononcent de façon quasi automatique la servitude pénale à perpétuité sans démontrer l'existence des circonstances aggravantes, comme l'exige pourtant l'article 77.
So this non-application of the death penalty results in my view, a too harsh application of Article 77, and Congolese judges tend to apply or to sentence people to a lifelong sentence automatically without demonstrating that there were aggravating circumstances as foreseen by Article 77.
Et par ailleurs, la pratique judiciaire congolaise reste marquée par une ambiguïté, puisque ces peines très lourdes, prononcées sans être motivées, ne sont exécutées que très partiellement au regard de la fréquence et de l'ampleur des évasions dans les prisons en RDC.
When it comes to legal judicial practice in Congo, we see that the application of these measures is very ambiguous because very harsh sentences and long sentences are pronounced. But you must know that in Congo there is a very high rate of people breaking out of prison. So in practice, the sentences are not enforced.
Je vais aborder à présent la question des droits de la défense. Ces procès sont-ils équitables à l'égard des accusés?
So now the next question is, are these trials fair vis-à-vis the accused?
Théoriquement, les juges congolais s'efforcent autant qu'ils peuvent de respecter les droits de la défense.
So in theory, Congolese judges do their utmost to respect the rights of the defense.
Toutefois, la pratique révèle certaines limites très préoccupantes.
Though in practice there are very concerning limitations.
Premièrement, la célérité excessive des procès due au timing trop court imposé par le bailleur de fonds dans certains procès, comme dans l'affaire Kibibi et consorts.
So very often judges have to rush through the trial because of a very tight schedule, sometimes imposed on the judges by the donors, like in the Kibibi case.
Ensuite, il y a le rôle ambigu de certaines ONG qui financent les chambres foraines d'un côté et qui ont certains intérêts dans la condamnation des accusés.
So secondly, there is the ambiguous role of some NGOs that finance some mobile courts in Congo, but also have a vested interest in seeing the accused convicted.
Et troisièmement, enfin, il y a un usage parfois abusif des témoignages anonymes de victimes de violences sexuelles protégées par le système de l'anonymat. C'est le cas dans l'affaire Colonel 106 et le procès de Minova.
And one more point is the abuse, that they use too much anonymous witnesses, in particular in cases of sexual violence, and that was a problem particularly in the Colonel 106 and the Minova cases.
Le dernier point touche la place des victimes dans ces procès. Et comme je l'ai dit avant, ici je vais me limiter à la question du droit à la participation ainsi que le problème de l'indemnisation.
So last but not least, I'm going to speak about the victims, their role in the proceedings, and their right to participate and their right to get a compensation.
Alors, par rapport au droit à la participation et à la sécurité des victimes, les juges congolais ont fourni beaucoup d'efforts pour protéger les victimes en s'inspirant de la pratique de la Cour pénale internationale.
So when it comes to the protection and safety of victims, Congolese judges do their utmost to give protection to the victims, and in doing so they were very much inspired by the practice of the International Criminal Court.
Néanmoins, cette protection reste limitée à l'emploi de codes et à l'anonymat, y compris lorsque l'accusé connaît déjà l'identité des victimes et les menace physiquement, comme dans l'affaire Colonel 106 et l'arrêt Kakwavu.
So the only protective measures taken are the use of codes and pseudonyms, or anonymous witness statements, even when the accused already knows the victims and can threaten them physically, like happened in the Colonel 106 and the
Kakwavu case. Yeah. Ensuite, la sécurité des victimes reste menacée par la fréquence et l'ampleur des évasions dans les prisons congolaises, comme on l'a dit précédemment.
And victims do not feel safe because, as I said, there are many breakouts and evasions and people escaping from Congolese prisons.
Et c'est une affaire qui ne concerne pas que les victimes. Les magistrats aussi sont inquiétés par ces évasions.
And the judges too are very much concerned by people escaping from prison.
Alors, par rapport au droit à la réparation ou à l'indemnisation, ce droit reste marqué aussi par une ambiguïté.
So now moving on to the right to reparation or to financial compensation, here too there is a huge ambiguity.
D'un côté, les juges allouent d'importantes indemnités aux victimes, souvent contre la RDC en tant que civilement responsable pour les crimes commis par les militaires et les policiers.
So on the one hand, the judges grant significant financial compensations to the victims, very often against the DRC, the DRC being liable from a civil point of view through the crimes committed by its soldiers or its police forces.
Et de l'autre côté, ces condamnations civiles ne sont pas exécutées depuis le tout premier procès de 2006 dans l'affaire Songomboyo.
And on the other hand, since 2006, we see that these decisions rendered by the courts are not being implemented by the states.
Les victimes semblent ainsi bénéficier d'une victoire à la Pyrrhus, puisque finalement elles n'en tirent aucun avantage concret.
So the victims at the end of the day do not get any benefit from this victory, this Pyrrhic victory in the courtroom.
Et donc je vais conclure à présent. À beaucoup d'égards, le respect de standards internationaux en matière de justice pénale reste encore un idéal à atteindre en RDC.
So, in many ways, respecting and complying with international standards when it comes to criminal justice is still a huge challenge in the DRC.
Néanmoins, l'expérience congolaise montre que même en l'absence d'une volonté politique, la répression des crimes graves reste possible grâce au dynamisme des acteurs judiciaires, donc les juges, les procureurs, avocats.
Nevertheless, our experience in the DRC shows that even without a political will, it's possible to fight crime and grave crimes because of the dynamism of all players in the justice system, including judges, prosecutors and lawyers.
Elle permet par ailleurs de prendre la mesure des difficultés rencontrées par ces mêmes acteurs judiciaires.
And this experience allows us to better grasp the problems and difficulties these players encounter on a daily basis.
Elle permet enfin de souligner la nécessité de la communauté internationale de soutenir ces acteurs judiciaires dans cet effort afin de renforcer la qualité de cette justice et surtout son effectivité.
And it shows that it's important for the international community to support the key players in the justice system in Congo in order to bolster the quality of justice that is given to victims.
Il faut rappeler ici qu'il s'agit des crimes qui, comme le dit le préambule du statut de Rome, intéressent la communauté internationale dans son ensemble.
And as said in the preamble to the Rome Statute, these crimes are a concern to the international community as a whole.
Je vous remercie pour votre attention.
Thanks for your attention.
Merci beaucoup Jacques. Emmanuel, à vous.
Je vais rapidement enchaîner. Comme on a me présenter, je m'appelle Emmanuel Kabengele Kalonji de la société civile congolaise.
So I'm going to continue. I'm Emmanuel Kabengele from the Congolese Civil Society.
Je vais vous parler du contexte actuel de la lutte contre l'impunité des auteurs des crimes graves en République démocratique du Congo.
So I'm going to talk about the current context in the fight against impunity for perpetrators of serious crimes in the DRC.
Le docteur Jacques a plus parlé de la jurisprudence congolaise, donc la réponse congolaise aux crimes graves.
So Jacques talked about the jurisprudence, the case law in Congo, and that is the response of the state to the serious crimes committed within its territory.
Dans le cadre de ma brève communication, je ferai état de 2 points.
So I'm going to put 2 points forward and to underline 2
Le
points.
premier point, c'est brève description du tableau actuel en matière de lutte contre l'impunité des crimes graves en République démocratique du Congo.
So first I will describe the current context when it comes to fighting against impunity for serious crimes committed in the DRC.
Et le deuxième point, c'est le lien que nous faisons entre la réforme du secteur de sécurité et la réforme de la justice.
And the second point will deal with the link between the reform of the security sector and the reform of the justice sector.
Déjà en termes de tableau, Jacques vient de nous donner pratiquement la température de la réponse judiciaire au cas de crimes graves.
So Jacques has briefly taken stock of the way in which we deal with serious crimes in the DRC.
Mais mon objectif ici n'est pas de faire un état des lieux de l'administration de la justice en République démocratique du Congo.
So my purpose is not to take stock of the way justice is rendered in the DRC,
mais plutôt faire une brève évaluation sur le moyen dont dispose le système judiciaire congolais pour donner réponse aux victimes de violations de droits de l'homme commises pendant la période de conflits armés.
But I'm going to briefly present the means that we have to help victims of violations of human rights committed during armed conflicts.
Dans la communication de Jacques tantôt, il a fait voir qu'il existe une volonté des acteurs de pouvoir faire en sorte que le crime ne reste pas impuni, mais la volonté seule ne suffit pas.
So Jacques just showed that there is a willingness in Congo to make sure that the crimes committed do not remain unpunished. Unfortunately, it's not enough.
À ce niveau, nul ne doute qu'aujourd'hui, aux yeux d'injusticiables moyens de la République démocratique du Congo, pour tout un moyen, la justice incarne l'injustice, la justice incarne la corruption, la justice incarne le tribalisme, la justice incarne la magouille, et ce justiciable moyen vient à la justice en tremblant parce qu'il ne sait pas exactement quel est le sort que lui sera donné.
So in Congo, for the man in the streets, justice means corruption, tribalism, trickeries, irregularities, and when they go to a court, they basically shake in their boots, so to speak, because they do not know what justice has in store for them.
Et le contexte actuel peut être décrit comme le contexte d'une soif non étanchée de la justice.
And in the current context, we could say that people are eager for justice, that they are thirsty for justice, but the thirst cannot be quenched.
Plusieurs personnes ont été tuées.
Several persons have been killed,
Et la plupart des victimes continuent à réclamer justice.
and there are still victims today that demand justice for these crimes.
Il y a une réponse judiciaire et comme l'a dit Jacques, cette réponse est insuffisante.
And as Jacques said, the response that has been given to this crime is not sufficient.
Ça m'amène au lien que nous faisons entre la réforme du secteur de sécurité et la réforme de la justice.
I now get to the point when I'm going to speak about the link between the reform of the security sector and the reform of the justice system.
Pour nous, la base de la réforme du secteur de sécurité, c'est la renaissance de la confiance de la population vis-à-vis de ses institutions, vis-à-vis de son armée, vis-à-vis de sa police, vis-à-vis de sa justice. C'est-à-dire qu'on a affaire à une population qui n'a pas confiance dans son institution et reformer cette institution voudrait faire en sorte que cette confiance renaisse.
So this reform is based on restoring the trust that the population has in its institutions, in its army, in its police, in its justice system, because at the moment there is too much mistrust in the institutions.
C'est ce qui fait que dans certaines littératures, on ajoute au mot réforme l'aspect réforme transformationnelle du secteur de sécurité.
So some writers have said that on top of reforming the sector, we need to transform the sector.
Les traitements de plusieurs affaires au niveau des juridictions congolaises, comme a eu à le démontrer Jacques, laissent toujours subsister une soif accrue du besoin de justice et réparation pour les victimes.
So several cases, as explained by Jacques, show that there is an eagerness that people are anxious to get reparation for the harm they suffered.
Et pour celles qui s'en sortent avec une reconnaissance au moins judiciaire de leur état de victime, elles se trouvent toujours confrontées au problème de réparation. Et Jacques Aïa le soulignait.
And even for those who get a recognition from a court, there is still the issue of getting reparation after the legal proceedings.
Surtout que dans la plupart des cas, le civilement responsable reste l'État.
Because in most cases, the party that is liable is the state.
Il est strictement difficile de voir l'État s'exécuter librement dans les décisions de justice qui les condamnent en réparation civile actuellement en RDC.
And it's difficult to imagine the state actually implementing or enforcing the legal decision taken against him.
Et les accords de paix interpestifs avec des groupes armés ne peuvent pas réellement amener à la consolidation d'un état de droit.
And the multitude of peace agreements signed with armed groups cannot lead to a sustainable rule of law in Congo.
Étant donné le fait que ces accords aboutissent si souvent au processus d'intégration de groupes armés dans l'armée nationale, où il existe tout de même des limites à ne pas franchir.
Because these agreements result in the incorporation of these armed groups in the national army, where there are lines that you cannot cross anymore.
Car comme le faisait remarquer un haut diplomate belge, à force d'incorporer les indisciplinés, on incorpore l'indiscipline.
As a Belgian diplomat said, through incorporating undisciplined elements in the army, you actually incorporate this lack of discipline into the army as well.
Et selon une étude citée par un auteur, sur les 313 conflits armés entre la Seconde Guerre mondiale et 2008, seuls 17 ont donné lieu à des poursuites contre 40% des amnesties et moins d'1% de criminels ont été traduits en justice.
According to a study, out of the 313 conflicts between World War II and 2008, only 17 gave rise to prosecutions, and in these 40% resulted in amnesties, and only 1% of the criminals and the accused were actually convicted.
Donc le problème qui est global, qui n'est pas seulement pour la RDC, suscite une interrogation sur la vraie manière de pouvoir étancher cette soif de justice.
So the question that arises from this problem, which is not only a Congolese problem but a global issue, is how to quench this thirst for justice.
Autant il est important de prolonger l'action des juges nationaux par une réforme de la justice et du secteur de sécurité, autant au plan international aussi, il est important de prolonger l'action de la Cour pénale internationale par une attention soutenue des acteurs de la communauté internationale à la réforme du secteur de sécurité en République démocratique du Congo.
So in this reform of the security sector, of course it's important to extend the powers of judges, of domestic judges, but at international level it's also important to support the work of the International Criminal Court and of the various players that are involved in this process.
Voilà l'essentiel que j'avais à dire, je vous remercie.
Well, that's basically all I had to say. Thank you.
Merci beaucoup, Emmanuel. Et maintenant, Franck, le dernier.
Yeah, thank you so much. I think most of the issues have been raised. I wouldn't go too far, but as you know, there's a principle saying justice delayed is justice denied. Meaning the time you take for justice in the minds of victims, it's really, really a concern. And this is one of the lessons that we have learned from this study. And what I was asked to do was just in 5 minutes discussing a little bit few lessons that we've got from this study. And the first one is that where natural justice can get the capacity, there is a possibility to deliver. And we've actually realized how substantive was the collection of this jurisprudence that actually has been presented for Open Society Foundation. That was really, really one of the best practice in the region. And I remember when we met in Dakar for a meeting in the region, meeting on colleagues working on international criminal justice. This study was one of the very first study in the region, actually, collecting the capacity of a national justice system on international crimes. And the global or the regional perspective for international crimes in the African region relies on the International Criminal Court. And for the last few days, we've been actually interacting with the ICC. There is a lot to say about the timing between the investigations of the International Criminal Court to the time victims can expect to get justice. And one of the judges this afternoon was saying the minimum we could expect is 5 years. Just imagine 5 years for a victim, what it means. So this means having a national system with the capacity to deliver on international crimes is the best thing a country can do in the conflict context. And this has been taken for us as a very good and one of the best practices in the region. There was an issue that Jacques and Emmanuel touched, is the willingness of the states to actually provide the meaning, financial and human capacity for the national justice system to deliver, especially in case where the perpetrators are state actors. Do you believe in a government which is accused of having perpetrated massacre or just crimes in a region to provide financial meaning to the national system to deliver? That's not something that is possible. But this is where we believe, out of the capacity and willingness of the national justice system, there is a strong need for the other stakeholders in the international community to provide wherever possible their support to where the system is actually starting, to make sure that what they've started actually make progress. And this is where I think it is so important to keep that in mind. And this could be really a very strong alternative where the International Criminal Court cannot deliver immediately. We can't forget the need and the persuasive power of the International Criminal Court for most of the big political powers in the region. But we need to take this part of work as an alternative for the victims that want justice to be delivered at their doors and immediately. So we've learned a lot in this study, and we have to keep that as really a big practice. On the issues around the indemnization for the victims, this is a really and you can go through the 70 cases that is in the book. Very few, I might maybe think of 2 or 3% of cases where actually victims have that. I won't talk about the whole compensation that is actually in the judgment, but at least some of them in few cases have been able to get a very modest compensation. So meaning there is a very strong need of having a deep thinking around the state and other stakeholders' response to the issues around compensation. There has been an initiative actually that was started in the DRC on the establishment of a national fund for victims of international crimes. And this is one of the lessons we've learned. But apart from the judgment, there is a need of making sure the victims that will actually be satisfied of having go to court and go to judgment, to effectively get compensation. There are people that have lost their properties. There are people that have been removed from the areas of living. There are people that have lost their belongings. They've lost their beloved ones, the whole family. But the simple fact of having a judgment said is not enough. This brings the ideas around the vengeance. How do you make sure, if you don't get the compensation, how do you find a way of compensating yourself? Maybe by killing someone else because you have lost your beloved one. So if you don't get the need support, the compensatory judgment, you need to actually find your own way to make justice. So it keeps a long crisis in terms of violence in communities, and doesn't really provide the idea of effective justice for the victims. That's something that we believe is a strong lesson that we've learned from this study, and we believe it is so important for us, not only for us as Open Society Foundations, but also for the civil society and other stakeholders working on this, to think of how do we engage partners in the region, in the country, to think of a special funding that could be availed to victims in terms of providing support when international crimes occur. Not because we want to encourage the crimes to happen, but when they occur, there need to be something that will provide victims the possibility to believe really. It's just part of the process. I mean, apart from the financial meaning, there is also all issues around the reconciliation processes and so on, and this has been going in DRC for quite a while. The other point I'll just maybe point out, it's the use of the theory of the responsibility to protect. I think for those who are actually incorporated in the development of the international criminal justice, they've seen how this theory has really made progress in terms of when a state is unable or unwilling to protect their own citizens, what are the limits of providing the space for international community to actually support the protection of the citizens where actually the state is unable or unwilling to do so? There is a space for further reflections on that as well, and I think it's one of the lessons that we have learned, because in most of these cases, in most of the cases, you really believe that there was a possibility for the state to protect. But despite that, there was a possibility to protect, they've not been able to do so, and the citizens have been victims because there was whether the lack of capacity or unwillingness to protect them. So for us, it's also something we need to reflect more and think of how we move forward. But the main thing we could keep in mind for now is that this is a starting point, and it has been taken as a quite successful study. And we believe we need to get your recommendations, we need to get your thought and your insight on how we can move this process forward in the coming years. We are very supportive of the study, and we want positive criticism and your recommendation in how we could move this forward. And the good thing also is that the study is actually almost done with the translation in English with our colleagues from Osiwa. We believe maybe in the coming weeks we may avail the study online on the website, or share it as well with the ASA Institute for those who might need to read it in English, to provide more space and more facility to better understand and deeper understanding of the content of the study. For now, we just want to thank you so much, and yeah, we are ready for discussion. Thank you.
Thank you so much, Frank. Thank you to all of you. To a very interesting presentation. I think you gave a very good insight into the prosecution of international crimes in the DRC. There's now some time for Q&A, and I'm trying to look for my colleague Eva, who has a mic, and otherwise I might walk the mic myself. And then I give the floor first to Thomas.
Thomas Fairfuss, Journalist for Justice. Je n'ai pas bien compris cette histoire de bailleurs de fonds et d'ONG. Donc, des bailleurs de fonds font pression sur des juges pour en finir plus tôt avec les procès avant une certaine date. Il serait donc nécessaire d'aller bien au-delà pour présenter plus de moyens de preuve. Quels sont ces bailleurs de fonds? Est-ce que ce sont des pays étrangers? Est-ce que ce sont des organisations internationales? Et la deuxième clarification que je vous demande, c'est sur les ONG. Il y a donc des ONG qui font pression sur des juges pour condamner des suspects qui ne sont pas coupables. Est-ce que j'ai bien compris? Qui sont ces ONG? Est-ce que c'est des ONG congolaises ou des ONG internationales? Qui est-ce qui les finance et qu'est-ce qui les motive?
Philippe, je traduis la question en fait pour le... So I'm going to translate the question very briefly. So there was a remark about donors in Congo putting pressure on judges, and the question is, where do these donors come from? Do they come from foreign countries? Are they international organizations? And same question basically for the NGOs. Who are the NGOs that put pressure on judges to obtain a conviction?
Yeah, I think it's very serious.
Sure, what you prefer?
C'est mieux comme ça, on va le
Group de questions? Okay. So let's assemble a couple of questions. Is there another one? Yes.
When you say the state is unwilling to dole out these reparations for victims, can you talk more about whether it's a problem of passing legislation or lack of money from the state? What is exactly the problem of the state, the barrier for the state giving reparations to victims?
Any other questions? Yes.
Oui, bonjour, merci beaucoup, c'était très intéressant. Je voudrais savoir un peu si l'idée d'un tribunal spécial existe toujours en RDC ou est-ce que ça s'est foutu pour le moment. Et puis aussi pour professeur Mbokani, je voulais savoir si les cours en RDC ont aussi employer ou utiliser les décisions de la Cour pénale internationale, par exemple Lubanga ou Katanga, c'est peut-être plus trop récent, mais en plus que le statut de Rome, les décisions aussi de la Cour.
So the question is about a special tribunal for the DRC to know whether this idea is still, current and ongoing, or if it has fallen through, maybe. And a question to Professor: do the Congolese courts actually use the case law of the International Criminal Court, like for example the Lubanga or Katanga cases? Do they use the jurisprudence of the ICC?
Let's maybe take these questions as the first round. And then maybe start with a question from Thomas Verfuus on the specific case and also the NGOs. Who are those NGOs basically that are trying to interfere?
Bon, moi je ne suis pas très à l'aise de citer ces ONG, mais je cite ici des références dans cette étude qui permettent de retracer l'action de ces ONG. Et par rapport aux bailleurs de fonds qui imposent un timing trop serré aux juges, je vous citerai l'affaire Kibibi dont je parlais ici, où c'était plutôt la MONUSCO qui avait aidé les juges à voyager et qui leur avait imposé 48 heures pour prendre l'affaire en délibéré et rendre le jugement. Et c'est des propos que un des juges m'avait dit. Et dans ce contexte-là, la qualité même du jugement n'est pas très bonne. Et encore que dans ce type de procès, ils prononcent d'abord la condamnation et ils vont rédiger l'arrêt pendant 2 ou 3 semaines après le prononcé. C'est de pratiques que je critique ici. Et je dis qu'il faut qu'on puisse intégrer aussi les juges dans la planification de du temps que prendra le procès, plutôt que de les mettre devant un fait accompli. Et donc, par rapport aux ONG, je préfère ne pas citer de nom ici. Je ne suis pas très à l'aise. Mais dans cette étude ici, vous aurez un peu plus d'informations par rapport à ça.
So
Alors,
I don't feel very comfortable naming and shaming NGOs here, but if you read the study, you will find information about specific NGOs and what they did. When it comes to the donors that impose a too tight schedule on the judges, and it's particularly relevant to the KBB case, which I mentioned earlier. In this case, the MONUSCO, so the UN peacekeeping forces in Congo, had helped judges to travel to some places, and they had given the judges 48 hours to deliberate and to render their decision, which is a very tight schedule. And I got that from one of the judges, so it's first-hand information. And in this case, the quality of the decision was at stake, of course, because, I mean, you have to hand down a decision extremely quickly. And in that type of cases, there is first a conviction, and then they draft the decision, which is made available 2 or 3 weeks later. So I'm very critical of this kind of practice in my country, and I think that judges should be better involved in the planning of their proceedings. And I repeat that when it comes to the NGOs, I'd rather not give names here.
Une autre question par rapport à l'emploi par les tribunaux congolais de la jurisprudence de la Cour pénale internationale. En fait, c'est une tendance que je relève ici. Ils ont souvent fait recours à cette jurisprudence, même si parfois ils n'interprètent pas toujours très bien les décisions. C'est comme dans l'affaire Lubanga à propos de la théorie de la coaction. Là, je trouvais vraiment qu'ils ont très mal interprété, mais ils ont fait recours à cette jurisprudence. Il faut aussi garder en tête que la plupart des décisions qui sont rendues aussi bien par la Cour pénale internationale que par les tribunaux pénaux internationaux sont rédigées en anglais. Et le temps de traduction prend parfois plusieurs mois. Et ça fait que c'est des décisions qui ne sont pas accessibles aux juges. Et troisièmement, enfin, il faut vous mettre en tête que ce sont des juges qui travaillent dans des bureaux qui ne sont pas informatisés, qui n'ont pas accès à Internet. Le téléchargement de 300 ou 700 pages de la décision Lubanga, ce n'est pas tout le monde qui peut se le permettre. Et donc ça fait que c'est tout ça le problème dont j'ai parlé ici, qu'il faut soutenir ces juges. Ils ont la volonté de bien travailler, mais les moyens font vraiment défaut.
So, when it comes to the second question about the case law of the ICC and its application by Congolese judges, there is a trend that I noticed recently, and it's that they tend to use the ICC case law, but it's not always well interpreted by the Congolese judges. And I will take as an example the co-action theory in the Lubanga case that was poorly interpreted by the domestic judges. So you must know as well that most decisions rendered by the ICC are drafted in English, and it takes several months before the decision is translated into French, which means that it's not accessible in the meantime to the domestic judges. On top of that, most judges work in offices where there is no equipment, they have no access to computers or to the internet, And in order to download a decision, for example, the Lubanga decision was like 500, 600 pages. It takes quite some time, and not everyone can afford that. So that's why it's necessary to support the national judges, because they have the willingness to do their work well, but they lack the means to achieve what they would like to achieve.
I would like to respond to the question on special tribunal, mixed chamber, special court, which are different name that different name, that was proposed. Were proposed. My response is the idea is not death, die. The idea is on the fridge. Is on the fridge for the moment. So the idea is not die, but it's somewhere in the fridge. Why? Because I think the current political environment is not allowing a deep debate on this issue. This last year were year with many discussion on the future of the electoral process and all this stuff, and even MPs are in this crazy moment where they are thinking about their own future. So the idea is on the fridge, but maybe going back to what happened somewhere in 2010, the idea of having a special tribunal or a mixed chamber in Congo came back. It wasn't a new idea. The idea just came back, and a lot of stuff were done in that moment, just to ensure that the process is going well, to ensure that different work are done to the content of the law, the content of the bill, and everything. But unfortunately, the process failed. The process failed somewhere in the parliament for a couple of reasons. One of the reasons was the issue of the death penalty, because it's still a controversial question in Congo. Many of us were advocating, for no death penalty in the bill, but it was an issue. Number two, I think, is the fact that the many Congolese political actors remain former militias members, and some of them had an interest to not see the bill pass. Number three is also, I think, the lack of coordination between different stakeholders, and unfortunately international NGOs also play like a malicious role in that content, just to take the front line, where because of the idea of sovereignty, Congolese in that moment were more keen to see a process led by Congolese. And when they see so many actors coming from different places in the world arguing because they need to see this special tribunal coming out, they also say, oh, we have our own judicial system. Why don't you strengthen the existing system, and rather than creating a new story? And this advocacy came also with the idea to have some international judge involved. And because of the idea of sovereignty, Congolese say, no, we have our own justice system. We want it to be strengthened, because otherwise you will create a situation where you have different type of justice in Congo. Judges very well paid and judge with a normal payment, judge very well protected, and judge of the normal system. So it was quite crazy. So I think all these circumstances made the project very difficult to defend in that moment. But the idea to have it remain, but as I say, it's somewhere in the fridge. Hopefully with a new regime, with new people, with new guys, we'll be able to come back and to claim for it, because the need remain in the country. There is many crime committed before 2002. There is many Congolese that are still expecting a true justice to be done, their story to be known, compensation to come out. So it's a struggle that we are still, fighting for. We have to continue in that direction. And to come back to the issue of reparation, it's many think it's a resources story, it's a financial resources story, and sometimes it's also an habit from Congolese judges to just consider one aspect of reparation. For example, what we call in French indemnisation, compensation, but not also going beyond this compensation. Other practice well known that can be also implemented. I never seen, for example, a Congolese judges coming out with some decision related to guarantee of non-repetition. You see, just to say that Congolese state should take A, B, C, D measure to ensure that in the future this kind of crime wouldn't be committed. So Congolese judges go many times to one kind of reparation, compensation, full stop. And most of the time it's difficult to identify how they come out to a specific decision on compensation, how they come out to a specific amount of money. Is it pain? Is it medical care that the victim needs? What is it about? So it's not clear how they come to that decision. And there is also, and this is also something good in that study, because this study is also addressing this issue. There is also from that study an opportunity to come back to Congolese judges and to see also what kind of new measures they can take into account to make things happen.
Sorry, just to add to what Nick has said on the reparations. I think it's true that lack of financial resources is one of the major issue. But at the same time, there is not a clear framework in which the reparations should be done. If a judge said you deserve $10,000 because what they did on you, let's take a case of rape, and that's it, he's done his job and he's gone. So you actually don't know how do you get that money. So you can say for 10 years without really knowing where do you go, how do you move around all the machinery in the justice system to actually get effectively the money. And there is a case in Songomboyo, I think the Songomboyo affairs, where over 300 women were raped. And because of the push from the UN Special Advisor on sexual violence in conflict, Madame Bangura, so they actually decided to do something and make sure by the next session at the UN in New York they have something to present. So what they actually did was to provide reparations for around 20 women that received between $300 and $1,000. What does it mean for women who have been raped like 300 times, or 3-4 times in front of the kids and so on? They lost the kids and maybe got sick, HIV and whatever you can imagine, for a $300 or $400, whatever it is. So it's a very, very important issue, and there need to be a quite substantive reflection on that to have a further discussion on the way forward. Yeah. Thank you.
Thank you for these very elaborate answers. Are there any other questions? Yeah, at the back.
Hello everybody, I'm Glyn Morgan. I'm an international crimes consultant based here in The Hague. I read that the new Special Criminal Court in Central African Republic has appointed a Congolese gentleman as the new prosecutor, which might sound a little ironic given the situation that you've described, but in Congo, is this considered to be a good thing in that it demonstrates that there is ability and capability within your judiciary, or is it thought of as a bad thing because it robs your country of somebody who could be quite important in this struggle against impunity?
Yes, Khalid.
Thank you. My name is Khalid Ahmed Chaudhry from International Human Rights Commission. Mid-2000 in Pakistan, the then powerful military dictator, he asked the Chief Justice of Supreme Court to step down. The Chief Justice wasn't a revolutionary either. There was corruption in Pakistan judiciary. It is still going on. But what happened? All of a sudden, Pakistan Supreme Court Bar Association and other bar association, all the lawyers, they decided to start a movement. And within next couple of months, this Supreme Court Chief Justice was reinstated once again. And then they started reforms within the judicial system as well. Africa have been suffering a lot, miseries, all kind of miseries Africa have suffered, the people. So my question to you is, for how long you and we will wait that some change will come, another regime will come, another ruler will come, and he will listen the plea of the victims? Isn't it possible to organize a movement within Africa, having all the bar associations from different countries, because Africa, you have different areas, corruption and all other issues, to start that kind of movement and to ask the Western countries as well to support that movement for a change. So then you can have reforms in judicial system and other things. Otherwise, I am afraid that another 10 years, 20 years, 30 years, we will be listening these horrifying stories and pictures. Thank you.
I think this gentleman as well. Yeah.
Merci. J'ai deux préoccupations, mais qui semblent être plutôt théoriques que vraiment pratiques. Lors de l'intervention de Jacques, il a développé une préoccupante question relative à la rétroactivité. Et entre autres recommandations qu'il donne, il dit que les juridictions militaires pourraient appliquer le statut de Rome, ou les juridictions congolaises en général, le statut de Rome, ou alors les lois de mise en œuvre du statut de Rome sur la simple ou la base du droit international coutumier. Le fait que les statuts de Rome ou les lois de mise en œuvre sont des instruments déclaratifs du droit coutumier, que ça serait alors une raison pour les juridictions congolaises d'appliquer ces statuts ou les lois de mise en œuvre pour les faits qui datent d'avant 2002. Alors, ma préoccupation est celle-ci. Il est généralement connu que les lois pénales ne rétroagissent pas, à quelques exceptions près. Alors, je veux savoir, est-ce que c'est un nouveau principe de droit que les instruments ou les lois qui consacrent, ou les lois pénales qui concernent la répression des faits dont l'interdiction est consacrée en droit international coutumier, toutes ces lois devraient rétroagir. Est-ce que c'est un principe général de droit? Peu importe le fait que ça soit une loi peut-être plus sévère. Okay. Yeah.
I'm just going to translate the first part of the question. So I have two main concerns, which are of a more theoretical nature, I believe. Jacques raised the question of retroactivity, and one of his recommendations is that military tribunals, courts and tribunals, and other courts and tribunals in Congo could be allowed to apply the Rome Statute and its implementing laws for crimes committed before the entry into force of the Rome Statutes, and that is 2002. Because it's only a statement of customary international law as it was back then. And my main concern is about the retroactivity of criminal laws. We know that in general criminal laws are not applied retroactively. There are a few exceptions to that. But is it a new principle under international law that laws passed in order to repress international crimes could be applied retroactively by domestic judges? So that's the first question.
Pour compléter la première question, je voudrais compléter la première question par ceci. Est-ce que à l'état actuel du droit international, l'on peut ressortir quelques précédents qui justifieraient l'application de la rétroactivité d'une loi pénale par le simple fait qu'elle serait déclarative du droit coutumier? Et pour entamer la deuxième question, je pense que c'est une question qui concerne LB, je ne sais pas si j'ai bien prononcé son nom.
Très bien prononcé en français.
Ah, d'accord. Et voilà. Vous avez, en abordant les questions de réparation, relevé le fait que les juges congolais, ils n'abordent que quelques aspects ou quelques modes de réparation, n'abordent généralement pas la question de garantie de non-répétition. Et c'est une question ou bien c'est un aspect qui m'a fait beaucoup réfléchir. Je me demande dans quelles circonstances ou dans quelles hypothèses pensez-vous qu'un juge congolais ordonnerait à l'État de fournir des garanties de non-répétition qu'une personne qui dépend de lui ou son organe ne commettra pas d'actes qui pourraient être qualifiés de crimes? Pensez-vous que cela est possible vraiment? Pratiquement, comment cela pourra se faire? Qu'un État soit condamné par un juge congolais à fournir des garanties de non-répétition, qu'un de ses membres, par exemple un membre des forces armées, ne se livrera jamais à la commission d'un acte? Qu'en est-il si demain il y a un acte en pratique? Demain, on se rend compte qu'il y a toujours des organes de l'État qui commettent des crimes de guerre, des crimes contre l'humanité ou des génocides. Quel sera le sort de ces jugements qui condamnaient l'État à fournir des garanties de non-répétition? Merci.
So, just to add to my first question, so as it is now under international law, are there precedents that could justify the retroactive application of the Rome Statute? And my second question to Nick, you addressed the question of reparations, and you mentioned that Congolese judges in general only take a few aspects of reparations into account in their decisions, and that they cannot give guarantees that the crimes will not be repeated, so there is no measures in order to prevent the repetition of these crimes, and under which circumstances could a judge force the state to take such measures in order for the crimes not to be repeated? And is it even possible to impose that on the state and to make sure that no agent of the state, the military, the police, will ever commit these crimes again? And what happens if such a crime like genocide, crimes against humanity, or war crimes is committed again? So these are my two questions to you, gentlemen.
J'ai juste une question et je suis pressé de répondre à la question. C'est la question du timing que peut prendre une réforme. Donc, il y a un intervenant qui a posé la question de savoir quel est le temps que peut prendre la réforme. On continuera toujours à attendre, que la réforme puisse venir. Okay.
So the first question I would like to answer is about the timing of the reform. And I think that the gentleman asked whether we need to wait again for 10, 20 or 30 years before things change.
Je voudrais de manière brève répondre en disant que la réforme peut prendre le temps qu'elle peut prendre.
Well, basically my answer is that reform will take the time it takes.
Tout dépend en principe de l'éthique et de la volonté des acteurs de faire avancer la réforme.
So all depends on the ethics and the willingness of stakeholders to move the reform forward.
Parce que l'idée, c'est en fait de faire gagner la confiance du public dans l'institution.
So the idea is to restore the trust of the people in its institutions.
Il y a des jalons qui peuvent être posés pour gagner cette confiance-là.
And we could reach some milestones in order to restore and achieve some things in order to restore this trust.
Il y a des choses qui peuvent se faire sans nécessairement beaucoup de moyens.
And things can be done with very few resources.
Il y a des choses qui peuvent se faire avec le concours de beaucoup de moyens.
And things can also be done with many resources, of course.
Alors, tout dépend de la volonté des acteurs pour pouvoir réaliser ce réforme.
So, everything depends on the willingness of the stakeholders to achieve something.
Il n'y a pas un timing précis.
So there is no precise time frame to these reforms.
Si la volonté est forte, peut-être qu'on peut prendre un raccourci.
So if the willingness is strong, we may take a shortcut.
Mais si c'est une volonté lente, parce que généralement, dans le cas de la réforme, il y a toujours l'idée de résistance.
But when you talk about reform, there is always some pushback.
Parce que la réforme introduit la notion de démocratie. La réforme introduit la notion de transparence. La réforme introduit la notion de tout ce qui fait obstacle à des comportements qui n'étaient pas crédibles. Donc, et ça rencontre de résistance.
And so when you talk reform, it means more democracy, it means more transparency, and then there will always be some pushback from people who do not agree with that and who want to keep as many hurdles as possible in order to slow down the process.
Okay.
So no more Amandala Nagavitu. No more. That Nelson Mandela's efforts and the South African people, they stood up against the apartheid regime. They could succeed into that. But I'm listening, I mean, that we'll have to wait that they go for reforms.
No, my response to this will be yes, more Nelson Mandela, more whoever. And I think that what you are saying, this is something happening now. Because the struggle is not over. People are struggling all the day long. People are struggling in all Africa, including in DRC. People are struggling for better life, better justice system, including with a lot of danger. I can tell you that today, this afternoon, I got an email from a partner on the field saying that He just received some treat through SMS. He has been called to attend a meeting in front of one guy in the security service system. But you know, he's stand up. He's not leaving the country. He's not going somewhere else. He is there. And there is many and plenty people like this guy. So the struggle continues. We are also aware that this struggle is bringing us also to some situation. When we talk about, the justice reform, implementation of, measures that are trying to handle the problem of compensation, the problem of justice for past crime. There is, as Emmanuel said, resistance. In the case of the Congo, I was saying about it before, there is many people within institution, within the army system, who were part of that bad story. They have no interest to see anything happening now. So for us and for everybody struggling for justice is also an issue of how to be creative, how to develop holistic approach, taking into account justice, taking into account also some other issue, how to make them friends so that we can make difference now. Sometimes we fail, sometimes we succeed. There is a couple of reforms that have been able to be passed. There is also some other which are still problematic. But the idea is to not stop. So I like to give that positive, perspective, just to show that the struggle continue, and there is many Africans that are up, including youth. And this is the kind of thing that is providing hope, that change is possible, and we have to keep, standing up in this issue. So I'm really in the same page like you. I feel your hunger, I feel the fire in you, and I think that there is many African and many guys within the continent that are like this. Thank you for this inspirational moment, I think. To respond to the question on Colonel Mutanzini, I like to start by saying that dealing with international crime and implementing the Rome Statute in Congo, first of all, we have to acknowledge that this is a new thing. We don't have 50 years of experience dealing with this kind of thing. This is a new thing. So this is a learning process. This is also something we have to acknowledge. That this study is bringing us to the development of the implementation of the Rome Statute and the implementation of, this journey of learning from Congolese justice system, especially military justice system. And you can see how some decision, how the book is bringing us from the worst decision to better decision. And what is fantastic in this book is the fact that there is no somewhere where the author is trying to accommodate writing with different reality or different story. It's just explaining to us how things stand from the worst decision to a better decision. From the first decision where Congolese judges were struggling to implement some mistake they've made, but also some clever, creative trying that they have made to implement the Rome Statute. So it's bringing you in that journey where you are learning how things happen in Congo. So this is a new thing, this is a learning process. And today, because of this experience, because of the expertise Congolese military judge especially were able to build, to develop, they become stronger than they used to be. They become more aware on the international system, international justice system, international crime that they used to be in the past. So today is more an issue of resources than an issue of expertise. There is still a couple of things to add in the way people are trained and everything, but mostly this is an issue of resources. We were talking about this issue of donor NGOs, pressure that they can put in judges, because these mobile courts are taking place in some remote area where there is maybe no road, no difficulty to access. They will need an helicopter from the MONUSCO to attend these places, and MONUSCO is saying we need 48 hours. But if you put the same judge in a good environment, clearly they will deliver. Clearly they will provide this kind of support that you need them to provide. So there is a huge issue of resources that should be resolved.
And just to confirm that Colonel Platin has been part of this crowd of innovative judges.
Absolutely.
Working with him since I believe the first decision that were handed down by judges. Mutazin was there. First as a prosecutor and then as a sitting judge.
Right, but in view of this lack of resources that you're talking about, your country is losing what sounds like a very effective prosecutor to go to an international court. Is that a good thing or a bad thing?
No, I think it's a positive thing. I think it's a recognition also of the work done by the Congolese military justice. And I'm pretty sure, because I was impressed when we deal with the validation workshop for the study. We have seen many Congolese military judges, very fantastic, explaining how they deal with making some decision happening, explaining their realities. And you see that there is plenty in the Congolese military justice system that can provide a very strong support. So for them, it's they are proud, to see one of them appointed in that new position, because they believe this is a recognition of what they have done from many here, and they believe also this is also putting them on light and putting also some pressure also to Congolese authorities to say, hey, guy, we exist, we are doing stuff, and people are recognizing us now. So if you can provide more resources, we can deliver better justice system. So I don't think this is Congo is losing. No, Congo is proud to see one Congolese recognized in this international environment. So it's a positive step, I think, for Congolese military justice system, and it's also an encouragement for them, to continue in that direction. And we really believe, because there is now competencies provided also to civil judges, that these Congolese military judges will come also to train their peer in the civil system. So there is an area of improvement, but what happened so far is also a big encouragement for the Congo justice system to show that everything is not worse. There is also positive things that are taking place despite the difficult environment where the judges are operating. And pour répondre à la question du collègue sur les garanties de non-répétition, on part du principe d'abord que il y a la séparation de pouvoir. Et la séparation de pouvoir fait sourire en général, parce qu'on se dit, est-ce que ça existe vraiment? Mais on part d'abord de ce principe.
So first, to answer the question of the gentleman there about the guarantees that can be granted by judges, there is first of all a principle that needs to be abided by, and that's the separation of powers. Well, usually people tend to smile when we speak about the separation of powers, but it's one of the key principles.
Alors, la même liberté qu'a le juge de condamner l'État à des réparations financières, c'est la même liberté qu'aura le juge à condamner l'État en vertu du principe, en vertu de ce mécanisme qui concerne les garanties de non-répétition. C'est le même principe.
So the judge has, on the one hand, the freedom to convict the state to pay financial reparation, and under the same principle, he has the liberty to order the state to provide guarantees that the crimes will not be repeated.
Simplement en demandant par exemple que la brigade A soit éloignée de tel endroit, que la configuration soit différente, en demandant un vetting par exemple pour que certains acteurs dans les forces armées soient retirés.
So for example, the judge can decide that Brigade A has to move away from a certain place, or that there is a vetting process in the army in order to make sure that some agents do not get involved in certain operations.
Ces choses sont possibles. Ça ne demande qu'un petit effort de créativité et ça vient compléter tout un travail qui est fait aussi par d'autres acteurs de terrain et une demande qui vient aussi de la population.
So all this is possible. It only requires a bit of creativity, and it also requires to support the work of the people working in the field.
Alors un juge pourrait aisément aller dans cette direction-là et être suivi.
So a judge could easily go down that way and be followed by the population that is eager to see justice in the country.
Ça ne sera peut-être pas une réparation financière, dont on sait que, par ailleurs, elles ne sont pas toujours exécutées, mais ça amène l'État dans une démarche qui consiste à rechercher des solutions pérennes à un problème récurrent au sein de sa société.
So maybe it won't lead or result in financial reparation, because we know as well that the financial reparation are not always implemented, but at least it will force the state to look for sustainable solutions to recurring problems in society.
Et le juge peut même à travers ça amener l'État à poser des actes de réforme nécessaires pour garantir que certains crimes ne se commettent plus. Ça ne signifie pas que le monde sera parfait, ça ne signifie pas qu'il n'y aura plus de crimes, mais ça signifie que l'État aura été encouragé à poser les actes qu'il faut pour limiter justement la commission de ce genre de crimes, pour détruire les facteurs qui amènent à ce que les crimes soient commis.
So in this way, the judge can prompt the state to take the necessary steps in order to guarantee that these crimes will not be committed again. Of course, it will never lead to a perfect world, but it will encourage the state to take these steps and to prevent the crimes being committed, as well as to get rid of the factors that could lead or that had led to the commission of the crime.
Je vais répondre à la question de Ézéchiel à propos de la rétroactivité de loi pénale.
So I'm first going to answer the question about the retroactivity of criminal laws.
Je commencerai par le remercier pour la pertinence de cette question, que je trouve que elle continue à diviser les pénalistes et les internationalistes.
So I would like first of all to thank him for this relevant question that still divides experts in international law and in criminal law.
Dans cette étude, je commence par poser les cadres juridiques qui comprend le texte juridiques internationaux et les textes juridiques nationaux.
So in my study, I first set out the legal framework that comprises both the international instruments and the domestic laws.
Et donc, il faut rappeler que le principe de la rétroactivité est un corollaire du principe de la légalité.
So I would like to remind you that the principle of retroactivity is an upshot of the concept of legality.
Et quand on parle de légalité, on renvoie aux sources de droit internes ainsi qu'aux sources de droit internationales.
And when you speak about legality, you actually refer to the sources both of international law and of domestic law.
Et le raisonnement que les tribunaux congolais ont avancé était de dire que le statut de Rome était applicable simplement parce qu'il était ratifié par la RDC et que la Constitution avait prévu que les textes internationaux régulièrement ratifiés par la RDC ont une autorité supérieure à la loi.
And so the Congolese courts have maintained that the Rome Statute was applicable because it had been ratified by the RDC. And that also in the Constitution it says that international instruments prevail over national law.
Alors, ici j'ai parlé du droit international coutumier, mais il faut également rappeler que les crimes qui sont prévus dans le statut de Rome étaient prévus par des conventions internationales qui étaient ratifiées par la RDC bien avant le statut de Rome.
So I need to remind you as well that in my study I mentioned customary international law, but I would like to mention as well that crimes under the Rome Statute are also to be found in convention that had been ratified by the DRC long before the establishment of the Rome Statute system.
Et parmi ces conventions internationales, il y a la Convention contre le génocide de 1948 qui a été ratifiée par la RDC depuis le 31 mai 1962.
And among those conventions, there is the 1948 Genocide Convention that was ratified by the DRC in May 1962 already.
Et donc le même raisonnement qui a amené les cours et tribunaux congolais à appliquer le statut de Rome reste aussi valable pour appliquer la Convention contre le génocide.
And so the reasoning that led Congo to apply the provisions of the Rome Statute also apply to the Genocide Convention of 1948.
Et je rappelle aussi que la RDC a ratifié les 4 conventions de Genève de 1949 depuis le 24 février 1961.
And on the 24th of February 1961, the DRC also ratified the 4 Geneva Conventions of 1949.
Ici encore, le même raisonnement qui a entraîné les tribunaux à appliquer le statut de Rome reste aussi valable pour cette convention, ces 4 conventions de Genève en matière de crimes de guerre.
And so the logic behind the application of the Rome Statute is also applicable to the 4 Geneva Conventions for the suppression of war crimes.
Voilà. Et donc, vous comprenez que l'argument de la rétroactivité ou non du statut de Rome n'est pas un argument qu'on peut mettre en avant pour éviter de réprimer ces crimes qui ont été commis avant 2002.
And so the arguments of retroactivity of the Rome Statute cannot be used to leave the crimes committed before 2002 unpunished.
Alors, à côté de ces textes juridiques internationaux ratifiés par la RDC, ici dans cette étude, je cite aussi d'autres pratiques, aussi bien au niveau national que international, où on voit qu'il y a eu des textes juridiques qui ont été appliqués de façon rétroactive, et je cite ici en particulier l'arrêt de la Cour suprême d'Israël dans l'affaire Eichmann, qui a avancé une argumentation très pertinente sur cette question-là. Et je m'arrêterai là.
And so there is as well the very relevant reasoning of the Supreme Court of Israel in the Eichmann case, which shows that some texts and some laws have already been applied retroactively in the past.
In view of the time, we're running a little bit late. I would like to conclude here. So thank you so much for your excellent, passionate questions and also very, very elaborate answers. I would like to thank everybody for coming to the Austrian Institute tonight. In particular, of course, our four panelists, so Nick, Jacques, Emmanuel and Frank. And don't forget Jonathan, who I think who has done a tremendous job tonight. And of course, we wish you all the best with your very important work in the DRC. Finally, I would like to let you know that there are 3 other interesting lectures coming up shortly. So on the 20th of June, the Hague Initiative for Law and Armed Conflict, or HILAC, of which Asser is one of the co-organizers, will host a lecture on IHL at sea, so celebrating the launch of the updated ICRC commentary to the Second Geneva Convention. And speakers will include Professor Lisbeth Lijnsaat, who is the legal advisor of the Dutch Ministry of Foreign Affairs, Martin Fink, who is a military lawyer at the Royal Netherlands Navy, and Bruno de Meijer, who is the legal advisor legal advisor of the ICRC. And this lecture will not be taking place here at the Asser Institute, but at the Humanity House in the city center. Then on the 23rd of June, we'll host, again here at Asser, a lecture on the role of the European Union in the adoption and implementation of the Paris Agreement, featuring Mr. Jacob Werksman, who is the principal advisor of the Directorate General for Climate Action of the European Commission. And then finally, on the 27th of June, ASSO will organize a clear seminar on the refugee crisis and EU cooperation with Mediterranean states. And speakers here will include Professor Alejandro de Valle Galvez, he's our current CLEAR visiting fellow, and Dr. Claudio Matera, the CLEAR representative of the University of Twente. Now, for these and other lectures, please check the website of the ASSER, or better, sign up to our newsletters or our mailing lists. And finally, please know that whenever possible, and especially when the lectures, of course, are related to international crimes, we will try to upload them on the International Crimes Database. Now, Frank, you have mentioned that the study will be translated into English. It might also be interesting to include as many cases as possible into our database, so that you ask at some point also a request for recommendations. Maybe if we disclose it to the international community as a whole, we can also analyze these cases, research them, and also provide some advice perhaps if needed. You can find this database at internationalcrimesdatabase.org. So again, many thanks for coming, and enjoy the rest of the evening. Thank you.